Okay, we're going to get going just to make sure we don't run out of time. I want to welcome everybody to our legislative overview today, and thank you all for joining us. I just have a few housekeeping things. We are recording this, and it will be out on our YouTube channel. Please mute yourself if you haven't already, and we're going to take questions at the end. Feel free to put any questions you have in the chat. Also, just kind of an FYI, save the date for CIP's regional conference. This year, it's going to be in late September. On the 28th, we'll be out in Ogallala. And on September 30th, we're going to be in Omaha. The Omaha date is going to be a hybrid of both in-person and virtual. So hopefully everybody can put that on your calendar and attend. Tracy, if we can go to our next slide. Just a brief overview of what CIP is. We are a federally funded department under the direction of the AOC. We facilitate a multidisciplinary network of judge-led teams across the state known as the Yrtc teams. The members of these teams are all local stakeholders, and they work to improve issues in their juvenile court system in their locations. Each team, they select their own projects and goals based on their community. CIP staffs all the Yrtc teams, and we provide technical assistance to the local groups, data collection, any resources they might need that we can help with. And we also try to do a lot of information sharing between the teams. And as I stated before, we have our regional conference in the fall. We have webinars and trainings that we open to the public and stakeholders, as well as every 3 years we have our Children's Summit, which will be next year. And this is eligible for CLE, and at the very last slide is the CLE number, if people who need that. So before we get started, I wanted to introduce our panel of experts. We have Judge Larry Gendler, who just retired from the Sarpy County Juvenile Court Bench. Sarah Helvey, the Program Director and Staff Attorney at Nebraska Appleseed. Bree McClarity, a Deputy County Attorney in Dodge County. Dennis Marks, who is a Sarpy County Public Defender. And Roger Robertson is the Deputy Director of Children and Family Services at Health and Human Services. And I am Mary Pat Coe, and I am a project specialist at the Court Improvement Project. And just to let everyone know, the Excel spreadsheet that you'll be looking at was created by me to help me keep everything straight during the legislative session. So the shorthand, the spelling errors, any other errors you see are mine and not the presenters. Judge Gendler, I am going to have you start first for me, please.
All right, thank you. And if I don't get to your questions to anybody, my email address is lgendler@aol.com. I just have a couple bills I'm going to talk about briefly, then I'm going to let others go ahead and chime in on some of them as well. LB 143 is a bill that I worked on with Senator Coulterman. I got to give a shout out to Sarah Helvey because she reviewed our draft before we finally submitted it. And there have been some issues in some smaller jurisdictions where, and actually larger ones too, where school districts were not aware that youngsters were transferring in as a result of a placement change. So essentially what this bill does is that when a placement change goes into effect, when that notice is issued by the department, if it's in the child's best interest to change school districts or schools, that a notice goes to the school district so they're aware of that change. And it also would give the school district an opportunity to contact the attorneys that are involved in the case if they have concerns about that educational best interest recommendation from the department. So that is essentially LB 143. And as that bill moved through the legislature, it didn't have any opposition at the end. Everybody recognized the need. The next one I want to talk about here briefly is LB 307, and part of that bill included an amendment from LB 354. So I'll start with the amendment from LB 354 first. Under the law, when a juvenile court considers a transfer to adult court on motions to transfer, those orders have to be issued within 30 days. There was no such requirement on the adult court side. So what this amendment did was require that those decisions on the adult court side also be made within 30 days. The remainder of the bill addresses right to counsel, and this has been an issue across the state for a number of years. And all of you probably recall that Senator Pansy Brooks' bill a few years ago required that all jurisdictions that were 150,000 or more appoint counsel for youngsters as part of juvenile court proceedings. In addition, if they're charged with a felony or if they're in detention, those youngsters would be appointed counsel. What this bill does is really give some remedies to some of those concerns that youngsters are appearing in court either without adequate representation or with questions about representation. So the bill assures through a Supreme Court rule that a youngster, before they enter a plea, may consult with a lawyer before deciding whether or not to waive counsel. This was a compromise. I have to give a lot of credit to Senator Turnbull also, because he worked with the county judges in coming up with a solution with Senator Pansy Brooks. So beginning next year in July, the Supreme Court will have established a rule that will provide for meaningful contact between a youngster who has not been appointed counsel, if they wish, prior to their entrance of a plea. So those are essentially the two bills that I wanted to discuss this afternoon.
Thank you, Judge Gindler. Sarah, I'm going to have you go next.
Sure. Thank you, Mary Pat, and thanks for the opportunity. This is sort of an annual tradition for me to present on this webinar, and I always enjoy it so much. So thanks for another invitation. I want to just mention one legislative resolution that we're following during the interim, and then the status of a few recent Bridge to Independence bills. At the webinar in February, I mentioned two bills that were introduced this session to expand the Bridge to Independence program. That's the program for extended foster care services and support to young people who age out of foster care to age 21. Two bills, LB 202 was introduced by Senator Pansy Brooks, and it would have expanded the B2I program to include a subset of youth with juvenile justice experience. And then the other one was LB 262, and that one was introduced by Senator Tony Vargas, and it would have clarified that young people are eligible for Bridge to Independence program regardless of their immigration status. Neither of those bills advanced out of committee, but we are hoping to do some work over the interim and see those possibly move forward next session. So I want to just follow up on that. I was also asked to mention with regard to the B2I program, the impact of LB 849. That was introduced by Senator Pansy Brooks back in 2020, and it was amended into LB 848, which passed in 2020, but had delayed implementation. So it goes into effect on July 1st, 2021, which I think is tomorrow. The summer is going fast. So tomorrow's implementation day. Regarding B2I, it permits young adults who attain the age of majority under tribal law, which for a number of tribes is 18 instead of our age of majority in Nebraska, which is 19. It allows them at 18 to enter the B2I program at that time, rather than requiring them to wait until the age of 19 to enter the state B2I program, because we were losing many tribal youth due to that gap year, just losing contact with them. So to be clear, under the statute as amended by the bill, tribal youth would enter into the state B2I program, although I believe there's some discussions for the future ongoing about creating a B2I-like program through the tribes via tribal courts and tribal social services, but as structured, it's still the state B2I program. The bill also recognized the second Monday in October of each year as Indigenous Peoples Day, in addition to Columbus Day. You may remember the discussion around that. That's the same bill. And then I wanted to mention a legislative resolution and interim study. That's LR 198. It was introduced by Senator Megan Hunt. It's focusing on examining Nebraska's practices relating to Social Security benefits owed to children in foster care. You may have seen there was an NPR and Marshall project, had an investigative story that I think was circulated quite a bit. If you haven't read it, I recommend. Finding that 36 states, including Nebraska, have a practice of applying to become the financial representative, or I believe the term is representative payee, under federal regs for the social security benefits of children in foster care in order for the state agency to keep the money owed to those children and reimburse the state for the cost of room and board without notifying those children of those practices. The investigation also found that 10 states, including Nebraska, hired for-profit companies to help them apply for benefits for children who may be eligible in order to increase revenue for the state. So the study is focused on looking more about what's happening in Nebraska, including Nebraska's relationship with Maximus, that's one of the contracting agencies, our notification practices relating to alerting the children's guardian ad litem or lawyer about the child's eligibility for Social Security benefits, the amount of benefits retained by the state in the past 5 years, and then a look at any regulatory or statutory changes to ensure that children are aware of benefits for which they may be eligible and how to receive those benefits. So again, that's LR 198, looking at Social Security benefits as a result of that NPR story over the interim. And with that, I'll turn it back to Mary Pat for the next person. Thanks.
Thanks, Sarah. I'm sure we'll all be watching that LR to see what happens with Social Security benefits. Bree, I'm going to turn it over to you to discuss the bills on your list.
Great, thank you. Hi, I'm Bree McClarty. I'm a deputy county attorney up in Dodge. Spent about 10 years working at the legislature as a staffer or as a lobbyist. I made the mistake of mentioning to Mary Pat that maybe it would be helpful to have a prosecutor on here, and here I am. So I'm not going to go over a lot of the policies. To be honest, the County Attorneys Association opposed some of these bills. So I'm really going to more talk about what's going to happen next and the implementation as someone who's in the court every day practicing. My practice is just juvenile court. So I have a lot of experience with both juvenile delinquency cases as well as child welfare cases. So the first one is Senator Colterman's bill, the educational notice one. Judge Gandler already talked about this. So just some things I wanted to flag for individuals that might be practicing as GALs or defense attorneys, or just kind of people that are watching it and seeing how this is implemented. So the bill talks about both the emergency, when it has to be required within 24 hours when there's an emergency removal. But I wanted to flag the change of place when there's a 7-day notice. So when looking at and checking that HHS is complying with this statute, it's important to note that they'll give us a change of placement notice. We typically call it a 7-day notice. Within those 7 days, legal parties can object. So HHS probably won't be notifying the school until they either get confirmation that none of the parties are going to object to the change of placement. So it's going to be implemented on that date, or they might wait till that actual 7th day when the change of placement is going to be implemented. So the child is going to be moved. Something else to note is sometimes for expediency purposes, sometimes HHS will put that change of placement in the case plan. Those are required typically to go to court about 7 days before. So they kind of consider that as their change of placement notice. It might be buried in the case plan. And then a lot of the times parties will either waive the 7-day notice on the record, or they may do something to kind of speed up so that the change of placement can take place earlier, but not necessarily on that 7th day. So it's just something to keep an eye out for as your kids are possibly moving. And it's great that all parties are in agreement, but making sure that HHS is following up with the school because it may not have that typical, here's the notice, 7 days, here's the actual change of placement. So that's just something as those practicing to keep an eye out on. The next one is LB 273. This is the Yrtc change of placement for treatment. Something important to note that I saw was that it does allow for the filing of an emergency change of placement by the Yrtc, which is the OJS, the Office of Juvenile Services, and that it has to be heard within 24 hours. This is pretty similar to like the detention hearing statutes we have. And as someone that practices, this does come in guns blazing really quickly. So it's going to be really important for those practicing and having a youth that's placed at Yrtc to make sure that you're getting that initial treatment plan that's required. I think it's 30 days or no, within 2 weeks of being placed at the Yrtc. So make sure you have that. And then you're supposed to be getting a case plan update on a monthly basis from Yrtc about your juvenile. So make sure that you're receiving that. It talks about, it's made pretty much like a HHS case plan where it has what the goal is and what the progress has been. Make sure you're getting that so you can be up to date going into that 24-hour notice. There seems to be a lot of confusion about the family team meetings that are supposed to happen when a juvenile's at Yrtc. That's supposed to be set up by the probation officer who invites the Yrtc team as well as the legal team. So definitely check and make sure that your probation officer is inviting you to those. So that way you can stay up to date, because if that hearing's within 24 hours and you're trying to play catch up about this new treatment, it's going to be hard for you to appropriately advocate for your juvenile, whether you're the state or whether you're department probation officer or GAL. So those are just some things to flag. And then also, if you as a defense attorney, county attorney, or even GAL have a recommendation for treatment for your juvenile that maybe OJS or Yrtc isn't quite on board with, you can actually file that motion for review. I don't know if this is widely known. I had to bug legal counsel from HHS to get it, but there is a specific email that is where you can serve HHS Yrtc. I'll put it in the chat when I'm done. So if you don't have it, definitely save it. Typically, I deal with John Baker, who's a legal counsel for HHS, but make sure you save it. That way, if you ever want to, you can make sure you can file your own motion, or at least hopefully get served and give notice for that. And then the one thing I wanted to note is it has in there reasonable attempt to notify the parent or legal guardian. Reasonable attempt's a pretty big term. So if you're the defense attorney or GAL, I would definitely make sure that you reach out to the parents as soon as you receive that notice on justice, just so that the parents can be there when we're talking about medical treatment for their child, especially if the child's being moved on an emergency basis. So while HHS has that responsibility, it's only reasonable attempt. So as an advocate for the juvenile, if you have that kind of relationship with their parent, definitely make sure that they know about it and they can participate, because it does allow for telephonic or video conferencing participation for that emergency hearing. The next one I'm going to talk about is LB 307. So I was actually involved a lot in the negotiations back and forth, cards on the table. The county attorneys were not a big fan of this bill, but we did get to a reasonable resolution with allowing for the automatic appointment of attorneys in felony cases in the remainder of the states, the other 90 counties. Something really important to note is each county is set up a little differently. Some may have a public defender. Others, like my county in Dodge, have what's called a defense bar. So that will change how the court is implementing the notice and the appointment of an attorney, either prior to that first appearance or at that first appearance. So check in with your county, especially with your county court staff, about how they intend to implement this. When we talk about detention hearings in my county or juvenile welfare cases where we're having a protective custody hearing, those appointments actually happen before we even get to court. So the attorneys have a chance to try and meet with their clients even prior to showing up that day. So check and see if your court is going to do it like that, or if they're going to have the kids come in for first appearance, appoint then, and then come back entry of plea to give them time to discuss with their attorney, look at discovery, that kind of stuff. Also important to note is how your court handles it. For example, mine in Dodge, we do it by appointment. So first appearance may be at 8:30, then there's a second one at 9 o'clock. Other counties do what's called cattle call, where it's at 2 hours, everyone's scheduled, they do the rights advisement all at once. So how this is implemented will really kind of be determined on how your juvenile court is set up. So just some things to note. I'm very excited that the Supreme Court provision was included, just because I feel like having the Supreme Court look at how every county does it, they might be able to create a better statewide solution that can accommodate all of these differences in how these counties, one, do public appointments for attorneys, but also how they even handle juvenile court hearings and first appearances. So that's kind of just some things to think about in LB 307. And then finally, the last one is LB 568. This one got out of committee. It's on general file, and we're still in negotiations about this. This is the truancy bill, LB 568. Again, unsurprising, the County Attorneys Association opposed it. But I will say we didn't oppose all of it. We love the money. The part that we opposed was specifically the complete removal of the court's jurisdiction for 3B truancy cases. But some things just to note, and these are the things that we're going to be talking about as county attorneys with Senator Pansing Brooks, is we as counties and county attorneys run our community-based services aid grant funding. So I work with my juvenile diversion director to do this. The additional money is going to be instrumental in keeping truancy cases that don't need to go to probation in the diversion program. And there's some really great things in LB 568. So I don't want to poo-poo on it as a county attorney, because we specifically love the fact that it is allowing for community-based aid funding to be used for juveniles under the age of 11. That is not something that's happened before. We've always been limited to those that could enter the juvenile court system, which is 11 and older. So being able to work with kids younger than 11, I think will in and of itself reduce a lot of those truancy cases because we can do early intervention in the elementary school years. Some counties like Saunders County have this fantastic program called the Arrive program, where they're actually in the school, in the elementary schools, working with juveniles and they start at 5 days. They're really helping to mitigate what's causing these truancy issues. And I think they're seeing a lot of cases aren't going to court, which is kind of what we're all hoping for. So we are really excited about that change in it. I will just note that it's enticing to say that this amount of money is going to solve the problem, but it's important to look at how that money is distributed. The community-based aid funding grant is very restrictive in how we have to allocate our money, what we can do to move money around. We have to really just guess at how much it's going to cost to do specific services. And if we go under or over, we're kind of left holding the bag. We can ask for sub grant adjustments, but it is very difficult to anticipate that and have enough funding on each side. So for example, here in Dodge County this year, we've been doing a great job of reducing our detention rates and our alternative to detention rates. So we only allocated, I think, about $5,000 or $6,000 for it because we had done such a great job trying to prevent that and work with the juveniles on a voluntary basis or outside of even the court system. Unfortunately, we had a lot of runaways this year, and we blew through that EM money so quickly that we had to take money from other programs to cover it. So I would hope that if CBA or the community-based aid was looking at changing and having more money for truancy, that it actually be separate from the other diversion programs so we can allocate that money just for truancy and can work and move the money around to address that issue, especially if the jurisdiction component is going to be removed. So that's something that as a county attorney, I'm going to be working on just because we are constantly watching that budget and looking at that aid. But that's just kind of something to think about with 568 and ongoing conversations that we're going to have with Senator Pansy Brooks and her staff, as well as with all of the nonprofit and advocacy organizations that are working on this bill as well. Because I think there is a solution. We just got to kind of try and figure it out over the interim. I'm sorry, I talk really fast, so I'm very apologetic for that.
Thank you, Bree. That was a lot of great information. I'm going to pass it over to Dennis Marks now, kind of to give us more of a nuance of the defense bar.
Thank you, Mary Pat. Don't worry, Bree, I talk slow, so we'll even things out. Okay.
Dennis.
You're a tough act to follow. Very nice job this morning. Well, I'm the fourth speaker, so a lot of the bills that I've been asked to talk about have already been discussed. I don't know if that's a blessing or a curse. I'll let you decide that. I do want to tell you that any opinions voiced by myself are my opinions. They're not based on a consensus of defenders overall. But with that, let's talk about a couple of the bills that have already been discussed. I think Judge Gindler and Bree both did a good job talking about LB 307. That's the attorney provision by Senator Pansy Brooks. She's been working on this for literally half a decade, and I know it's finally come to some fruition. This is the waiver of counsel bill. So this was something that I think is a good first step. I'd like to see it ultimately go farther, but the fact that juveniles in counties of less than 150,000 can get an attorney when charged with a felony or in detention is a good thing. I like Bree, I like the fact that the Supreme Court's going to come up with a rule so that counsel can talk to youth prior to deciding whether to waive counsel. I know in the past, sometimes parents don't want counsel involved. They think it's going to slow things down. They don't think that there's a need for counsel. They don't really understand the ramifications and the possible dispositions in juvenile court. And our clients oftentimes also just want to get things over with. They want to get things done quickly. So I don't know how much real thought goes into the fact that counsel can get waived. And I like the fact that they'll be able to talk with counsel about the pros and cons so that any decision in waiving counsel will be made knowingly, intelligently, and voluntarily. The 30-day decision that Judge Gindler talked about in the transfer hearings is, I think, very important too. It's a recognition that in these transfer hearings, these waiver hearings, time is of the essence, because oftentimes cases that are tried to get transferred to juvenile court, they tend to languish, and those are the kids that are in detention too. Very few of them are out in the community, and there's a lot of different reasons for that languishing. Some of which has to do with the court calendar, some of which has to do with calling experts. So the ability to get a decision out within 30 days is going to be a real helpful boon to both the youth and the attorney, because if there's an unfavorable decision, then that 10-day appeal period can kick in really quickly. The other bill I wanted to kind of talk about was LB 568, and I can understand why the county attorneys may have opposed a portion of that bill, but I think moving it out of the 3B and more of a 3A is a good thing. I've often said, and I've heard this said in other discussions with various stakeholders, that school truancy is really symptomatic of something else. There may be some mental health needs, there may be some physical issues going on, there may be some family dysfunction, there may be some lack of parental support that underlie the school truancy. And I think getting it out of the delinquency side, the status side of juvenile court is going to be helpful. It's just going to keep youth from entering the juvenile justice system on the delinquency status side. But youth who've been adjudicated, you're still going to be able to address the excessive absenteeism. So it's being moved, but it isn't disappearing. As far as being able to use diversion, that's a good thing. You know, our diversion program in Sarpy County has what we call the PASS program, and they do a really good job of tracking youth and school attendance and addressing issues and supervising and working with families. The thing with diversion is it's just like any facility is, that program is only as good as the staff that you have. So if you've got a good diversion program, then that's going to work out pretty well. So that's about all I've got on those two bills. I'll turn it back to you, Mary Pat.
Great, thank you, Dennis. I really appreciate having both sides of the coin there, from the county attorney's office to the defense bar. Now we're going to hear from Roger Robinson from HHS on a few bills that affect all of our children and families. Roger?
Hi, good afternoon. My name is Roger Robinson, and I'm the Deputy Director of Programs and Services for CFS, and I work with all the programs within CFS with our federal partners. So I'll start with LB 485. LB 485 was signed and approved by Governor Pete Ricketts on May 24th of this year. LB 485 is a pilot program that will be implemented from August 28th through September 30th of 2023. During this time frame, LB 485 will increase the child care initial federal poverty level to 185% and the redetermination for FPL to 200%. Once a child care household is initially approved for the program, they will be eligible for each subsequent 12 to 18 month redetermination as long as they do not surpass 200% FPL. Once the pilot program ends effective October 1st, 2023, the eligibility will revert to 130% FPL for initial households and 185% for FPL for each subsequent redetermination. Subsequently, after October 1st, 2023, households that were approved during the pilot program will remain on the program at each subsequent redetermination unless they surpass 185% FPL. The Department of Health and Human Services will release a request for applications seeking a private nonprofit organization with expertise in early childhood care and education to collaborate to conduct an independent evaluation of the income eligibility changes made in this bill. This evaluation will be completed by December 15th of 2023. We'll move on to LB 108. On May 26, 2021, LB 108 passed with an emergency clause and became effective May 27, 2021. This bill increases the gross income limit for expanding resource program households to 165% of the federal poverty level, up from 130%. The in-focus eligibility system cannot be updated to reflect this change until July 11th of 2021. Until in-focus is updated, DHHS is holding all applications pending if the household's gross income is between 130% and 165% of the FPL. If the case is already active, their benefits are being closed if their income is above 130% of the FPL to prevent overpayments. After July 11, 2021, DHS will process the applications and redetermine eligibility in the closed cases. LB 108 has a sunset date of September 30th, 2023. The department is working with finance and the in-focus team to create reports to determine the impact of LB 108 and provide a report to the legislature on our findings. The report is due to the legislature by December 31st of 2022. LB 306 is the Low-Income Household Energy Assistance Program. It became law on May 27, 2021. LB 306 has two primary components. The Department of Health and Human Services shall apply a household total annual income level of 150% of the federal poverty level published annually by the United States Department of Health and Human Services or successor agency. Secondly, DHHS shall annually allocate at least 10% of available funds for LIHEAP to weatherization assistance for eligible households as administered by DHHS or other agencies of the state. LIHEAP receives a set of amount of funding annually. Thus, increasing the income level will increase the number of households eligible for LIHEAP and will decrease the amount of funding available to households at or below 130% of the FPL. A workaround was established for eligibility staff to utilize until in-focus could be updated and the new income levels and benefit amounts. In-focus was updated on June 13, 2021, and this is currently effective. And LB 143, everyone else has done a phenomenal job explaining it for me, so I can pass this one. So Mary, back to you.
Thank you, Roger. Thanks for all that information on those bills. So that we have some time for questions, I'm going to just briefly go over a few of the interim studies that are out there and two of the legislative resolutions that I thought everyone would be interested in. First, as to the studies, LR 143 was introduced by Senator Stinner, and it's a study to examine the mental and behavioral health needs of people in Nebraska. Some of the issues they're going to look at is the number and location of mental and behavioral health providers in Nebraska. They're going to look at areas of the state where there are specific shortages of these providers, which I'm sure you're all fully aware of where those are, and what educational and residency programs are available, and also ways to recruit and keep mental and behavioral health providers in areas where we have those provider and service shortages. And they're also going to look at the impact that telehealth availability has in our state. The next one I wanted to talk about was Senator Wishart's LB 164. This is going to focus on problem-solving courts like drug courts, veteran treatment courts, mental health courts, and also problem-solving courts, in juvenile court as well. They're going to look at barriers to participation, how many people would benefit from these courts, what other problem-solving courts can be developed in Nebraska, the fiscal effect, any way to best expand any innovative programs we have out there, any statutory changes that might encourage more participation in these problem-solving courts. And they're going to look at which problem-solving courts are already a fixture in Nebraska. And I think we've all been impacted on, our families and children on problem-solving courts and how that can really move a case along for you. The last study I wanted to mention was Senator McAllister's LR 189. I almost bypassed this one, but I was sure glad I clicked on it. It's to look at the current Sex Offender Registry Act, which I thought, well, that doesn't impact us. Well, unfortunately, they're going to look at should juveniles adjudicated as sex offenders in other states have to register in Nebraska if they move here. And they're also going to look at should there be a tiered system that would look at things like risk level, seriousness of conviction, and the age of the person. And they're going to look at what changes could be made to our Sex Offender Act in Nebraska. So I would encourage you maybe to reach out to his office to see what exactly they are looking at in terms of our youth. Moving on to a couple of legislative resolutions that I'm sure people have been following. LR 25 establishes the Yrtc Oversight Committee. This is actually a continuation of the Oversight Committee that, due to the early recess from COVID, last year they didn't have time to complete all their duties, so they requested this extension in the report they submitted. Now, this committee can study the quality of care and related issues at Yrtcs, as well as provide oversight of administration and operations, also staffing practices and the planning. From the language, how I took it in the resolution is the legislature felt that their input and oversight was needed as HHS develops and implements their 5-year operations plan that was required by Section 434427 of Nebraska statutes. And I just wanted to make note that this oversight committee has full subpoena power to do their work. The last resolution I wanted to touch on before we open for questions is the Eastern Service Area Oversight Committee. This committee looks a little different than what was first drafted. The draft that is in effect is now the study is going to look at the Department of Administrative Services and the Department of Health and Human Services with respect to the award, the implementation, and the oversight of the child welfare contract and the bid process. The Oversight Committee can issue subpoenas after authorization from the exec board of the legislature. So I wanted to open it now for questions. We have, I think, plenty of time to address any questions people might have, either over the resolutions, what bills were discussed. If you can put them in the chat, or you can unmute yourself and ask. You're a quiet bunch.
Mary Pat, in this event, they do not have the unmute privilege.
Oh, well, I guess you're going to have to type in the chat then. Tracy, if they want, can you unmute them?
Mary Pat?
Yes, Dennis.
On the sex offender registration, I believe, and I may be mistaken here, I don't think so, but I might be. I think there was an 8th Circuit case a few years back that 8th Circuit Court of Appeals that said if you move into Nebraska from another state, you don't have to register. And then the Nebraska Supreme Court shortly thereafter said, I think we know better than the 8th Circuit. You do have to register if you come in from another state. So I think that's currently the status right now. I would imagine that that legislative bill is looking to kind of maybe correct that situation. But I know as part of a collateral consequence, we need to advise our clients when it comes to sex offenses, what the collateral consequence of leaving the state, whether it's for work, whether it's for vacation, education, or a change in residence, to be aware of that need to register in that other state.
Thanks, Dennis. That's great to point out. Well, it looks like I'm going to give you back time in your day if there's no more questions.
We
Yes.
do have a question. What's the process timeline for the process of creating the Supreme Court rule for consultation prior to waiver of counsel?
I can handle that.
Great.
The bill's a little vague. It just directs the Supreme Court to create guidelines by July 2022. There hasn't really been anything that came out about what that's going to look like. The Supreme Court's been pretty quiet, unless anyone knows differently. So by next July, we'll know, and that's about as, I think, as far as we got.
And I've typed a few more questions and comments that I have received privately.
I don't think I'm getting them, Tracy. Can you read those?
Okay. From one participant, I think this is regard to the sex offender registry. I don't think all states require juveniles to register. And Christine, I'm not sure what your question is referring to. Is it a guideline or a rule?
Is that with regard to the waiver of counsel?
I'm not sure. Yes, Christine says. So can anyone answer that?
It's to be a Supreme Court rule.
And I have a question on LB 568. When will LB 568 be taken back up by the legislature?
Well, it's still alive, and this was the first part of a 2-year session, so it'll be up next year. It's on, I believe it is on select file right now, but as we all know, more bills will drop in the first 10 days, so it's hopefully it will stay priority and we'll keep moving.
Sarah, I think maybe you can correct me if I remember correct. It advanced to select. I think Senator Geis and Senator Pansy Brooks planned on working on it over the interim. And I believe the speaker said that it would keep its priority designation. With those first 10 days while they're doing bill introduction, since it's a second session, they tend to start debate a little earlier than usual because they're not waiting for bills to get out of committee. So my guess is if a resolution where all parties agree happens over the interim, it could possibly be debated pretty early in January in that next session. I think I'm remembering the right bill with the party designation staying on, but Sarah or Judge Gendler can correct me if I'm wrong.
I think that's correct.
Any other questions from anybody?
Looks like, whoops, just lost my chat window. There is, I think, a comment. If it is helpful, I would just note that LR 29 committee had its first hearing on the 18th with background and history from Senator Kathy Campbell, a discussion of the procurement process from Senator Coulterman, and then some background on the most recent RFP process on the ESA from Tom Kenny, who represented Promise Ship in their lawsuit. The next hearing is on July 9th in the morning with invited testimony from FCRO and the OIG and Liz Ruska.
Great, I'll be marking that down in my calendar.
Mary Pat, one thing I forgot to mention in mine, and this is, I think, a pretty good group because I know a lot of attorneys on here practice both civilly and in juvenile court, is LR 167 by Senator Jen Day. It is going to be looking at possible conflicts or friction maybe we're seeing between those custody orders that are done in district court, but then when there's a juvenile case and we're talking about bridge orders or custody determinations there, those attorneys that maybe have specific examples that can kind of highlight where we're seeing this friction or this, I guess, disagreement. I know Senator Day's office would be happy and eager to get a lot of those examples to kind of get a good idea of what we're dealing with across, because it's so different with what some district court judges are willing to do, what some juvenile court judges are willing to do. It is very specific and local what possible issues there are, and sometimes case specific. So if you're a practicing attorney and you have examples where cases, especially in juvenile court, dragged on longer than necessary because of custody issues, definitely reach out to Senator Day's staff. I know that they really want that kind of information, so they can start looking at that and seeing if there's any clarifications that need to happen now that the bridge order statute's a couple years old, and we have enough information of how it's played out in other counties and across the state.
Great, thank you, Bree. Any other questions or comments out there? I appreciate all the information in the chat for everyone. It just makes our webinar richer in information. So love the sharing of ideas and information that other people have.
We do have one more question. Isn't the increase in community-based aid tied to the cost savings if children are not placed on probation for truancy?
Christine, I did hear that in testimony that could be one area they're looking at moving money. If they're not on probation, then maybe some of that money could be shared with community-based aid. I recall that in testimony as well. Give anybody another minute if they're madly typing. Otherwise, I really would like to thank all the presenters. We certainly can't do this without them. I love the fact that we've added to our panel. Thank you, Bree, for the great suggestion. And thanks, Dennis, for being a part of it as well. Thank you all for attending. Again, thanks for the input you've had in the chat. I think that just makes for a better webinar. And you've got about 11 more minutes of your lunch period to have. So have a great day.
Thank you.